So welcome to this Legal Aid New South Wales Law webinar, Citizenship, when clients cannot pass the citizenship test. My name is Kerry Wright and I work in the Community Legal Education branch at Legal Aid New South Wales. To begin, I want to acknowledge and pay my respect to the traditional owners and custodians on whose land we are broadcasting from today, and to extend that respect to any Aboriginal or Torres Strait Islander people joining us today or viewing the recording of the webinar. I'm here today with Roxana Zulfikar from the Legal Aid New South Wales Immigration Service. Hi, Roxana.
Hi, Kerry. Hi, everyone.
So the information today is general legal information, not legal advice, but we will tell you where you can send your clients for specific legal advice. There is a handout on your control panel, which is a copy of the presentation we're using today. So feel free to download that and use that to follow along. Just also to be aware that this webinar is for community workers. It's not for people who are thinking of putting in their own citizenship application, and we won't be answering questions about individual cases, but general questions are fine. So the next slide coming up is what we'll be covering in this webinar. So there'll be an introduction to the immigration service, which Roxana works in, and who we're talking about, the citizenship test and who is exempt, when the immigration service can help, and we'll also take your questions at the end. So to start us off, Roxana, do you want to tell us about the Legal Aid New South Wales Immigration Service?
Yeah, so at Legal Aid we have about 10 lawyers who specialise in immigration law, including citizenship. And we cover a range of immigration topics, including family and humanitarian visas, visa cancellations, and the current COVID travel restrictions as well. And depending on the topic and on the client's circumstances, we may offer, well, for everyone we offer advice, but then we may also offer some short-term assistance or even full legal representation in some cases.
Okay, thank you. And who are you talking about today in this webinar?
Okay, so today's webinar is relevant for people who hold permanent visas, also known as having permanent residency or PR, and who want to become Australian citizens. So the permanent visa could be any type of permanent visa, including protection or humanitarian visas. But the webinar, oops, sorry, I just have an incoming call I need to get rid of. Sorry. So the webinar is not relevant for people applying for citizenship on other grounds, like, for example, citizenship by descent. Just to mention that, you know, as I'm sure you all know, that in addition to the citizenship test, which we'll be focusing on today, there are other requirements to gaining citizenship, such as meeting the residency requirement, establishing identity, and being of good character. But today I wanted to cover this topic about alternatives to the citizenship test, because I know there are many migrants and refugees in our community who would love to become Australian citizens but are unable to sit or pass the test for a whole range of reasons. So I think we have a quick poll before we get into it. Is that right?
Yeah, so I'm going to launch this poll question now for everyone to participate in who's on our webinar. So the poll question is, are you exempt from the citizenship test if you cannot read or write in any language? And the answers to choose from are yes, no, or unsure. So we'll just give people a few minutes to make their choice, and then we can talk about that, Roxana. So we'll see how many people are voting now. No, I don't actually know the answer to this question, so that'll be good information for me too.
Yeah,
okay.
I feel like it's not intuitive, so no one should worry if they're not sure of the answer. Just have a guess.
Okay, all right. So looks like most people have voted now, so I'm going to close it and share the results with you, Roxana. So you can see most 50% said no, 40% unsure, and 10% yes. So what
Hmm.
is the answer, Roxana?
Yeah, so you're on track there. So illiteracy on its own is not a ground to be exempt from the citizenship test. Although, as I'm sure many of you know from your clients, that if people can't read or write in English, let alone any other language, it's very difficult to study for the test and to pass it.
Okay,
Yeah.
well, that's great. Thank you. All right, so we know one new thing. So on to the next thing.
Mhm.
So what help is available to people then, Roxana, for the citizenship test?
Okay, so before we talk about exemptions, I just wanted to cover for people who will need to do the test, what kind of help is available. Um, so you probably all know that there are some study resources available. There's material on the Department of Home Affairs website, including a booklet in English and in some other languages. They also offer a podcast and some videos on YouTube. And then there are also some online resources you can find from other organizations. Like I did a search and I found some good material from the Illawarra Multicultural Service. There's something on the SBS website. And there's an organization called the Australian Test. I'm sure there are many others. So another, I guess, facility that's kind of offered is that applicants are generally given 3 attempts to pass the test before their application will actually be refused. Um, so, people should use those 3 attempts if they are feeling capable, and that might give them enough of a chance to pass. Then we have this is particularly useful for people who are illiterate, is some reading assistance when sitting the test. So now when people go to do the test, I believe all the computers are meant to have headsets attached, and there's an option to choose to have the questions and answers read out loud. If that feature isn't working, then the applicant can ask the test administrator to read the questions and answers out to them. And there's also the test administrator on site is also meant to assist if applicants need some help due to poor computer skills, or perhaps an injury that means they can't use the computer themselves. Then, as a final kind of thing that's available, is what's called the assisted test. What that really means is that the person will be given extra time to complete the test. And this is available, at least in the department's policy it is. I actually haven't heard of any examples of this being offered or used recently, but it's available for people with low literacy skills. And this is the way that they assess if someone's eligible for that is that the person should have completed at least 400 hours of English language tuition through AMEP, and that the AMEP provider has assessed them as having less than basic reading skills in English. And that is something the department is meant to be able to see through their computers. So yeah, they're some of the things that are available that you may not have been aware of that can be asked for if your client needs them.
And so the test is only in English, Roxana. When you were talking about the
Yes,
reading assistance, they can't choose a language. It'll be read in English.
it will be. It is in English, and part of the purpose of the test is actually to assess whether they have basic English. So,
Okay.
yeah.
Okay, you ready to move on?
Yes, thanks.
Okay, so who does not need to do the test?
Okay, so um, some migrants and refugees have pathways to citizenship that don't involve the test at all. So they are applicants who are under 18 years old. Um, so generally, children under 16 are included in their parents' application. Um, Children who are 16 to 18 can make their own application. So if you have a 16 or 17-year-old who wants to apply for citizenship, keep in mind that it might be advantageous for them to apply before they turn 18 so that they're not required to do the test. Okay, then other people who don't need to do the test are applicants aged 60 or over. And then two other categories that we're going to talk about in more detail, which are people with hearing, speech, or sight impairment, and also people with mental or physical incapacity or impairment. And we'll go into this, but it's it's not enough to just say that you meet that criteria. There are some very specific ways that you need to show the department that you meet that criteria.
Okay. So tell us a bit more about hearing, speech, or sight impairment and what the law says.
Mm-hmm. Yep. So the law says that this is where the applicant is suffering from a permanent loss or substantial impairment of hearing, speech, or sight, and it has to be at the time of the application. However, in this pathway, the person must understand the nature of the application at the time when they apply. I mentioned that because that's a bit different from the next category we're going to talk about. Then to use sight as an example, so the department's policy says that in this situation, what should be provided is documentation from a specialist ophthalmologist, regardless of when that report was issued, in addition to a recent report from an optometrist or orthopist, sorry. And they're saying if you provided those two reports, that is likely to be sufficient evidence of permanent loss or substantial impairment to sight. And the department's policy also sets out what this report should contain. So things like the degree of loss of sight, whether it's permanent loss or substantial impairment, how long the person has had that loss of sight, what aids they use to function in the community, if any, and full details about these specialists' qualifications and the date the report was provided. So I mentioned all this because the department's policy is not accessible by most people. It requires an expensive subscription. So it's hard for people to just find out what they need to provide. But this is one reason we're offering this webinar, and also why Legal Aid offers advice on this topic. I'll also mention that the policy says that in some cases overseas specialist reports may be accepted, and it notes that a GP report, while it could be provided as well as the specialist reports, it's not by itself is not sufficient.
Mm.
Yeah.
Okay.
Thanks, Gary.
So what about mental or physical impairment?
Okay, so this is a separate pathway to that previous one. This is where the applicant has a permanent or enduring physical or mental incapacity. Again, it has to be present at the time the person made the application. And that physical or mental incapacity has to be the reason why the person meets one of these other three requirements. So either they are not capable of understanding the nature of the citizenship application, or they are not capable of demonstrating basic knowledge of English, or they are not capable of demonstrating adequate knowledge of Australia and the responsibilities and privileges of Australian citizenship. I think that means, in other words, they're not capable of passing, answering the questions in the citizenship test. So someone might have might meet all three of those requirements, or may just meet one of them. But as I said, those kind of inabilities have to be caused by the physical or mental incapacity, not due to some other reason, such as general illiteracy or lack of time or other responsibilities. Again, for this pathway, there is very specific requirements about the evidence that should be provided. Again, they're looking for specialist reports. And I'll just mention a few points about what the policy says. So there is an explanation of what permanent or enduring incapacity means. So enduring incapacity is one for which there cannot be a predicted recovery, or where there is, it is long term. And they provide some examples. So for example, if a person has a congenital birth defect or suffered a stroke and their prognosis of recovery is not predictable. It says when assessing a person who is suffering from long-term depression, one consideration would be whether the depression can be treated and to what extent the person is incapacitated as a result of the depression. These are factors that should be addressed in the specialist report. Another example given in the policy is that a person with a broken limb would not generally meet this requirement because their incapacity wouldn't be permanent or enduring. However, a person with severe spinal injury resulting in brain damage may meet the requirement. So just as an example, so I have had clients with severe depression, anxiety, and PTSD who have managed to meet this requirement. They're obviously situations where those mental health conditions were long-term and for which there was no predicted specific time frame for recovery. My clients also happened to be illiterate, but the reports explained that it was their mental health conditions which affected things like their sleep, their memory, their concentration, and because of that, they were unable to learn enough English to sit the test or to retain information sufficiently to sit the test. Thanks, Kerry.
Okay, so we'll move on. So this slide is asking, you're going to talk about issues with demonstrating incapacity.
That's right, yeah. So it's a very technical area, and it's as I said, the policy is not very accessible. So I'll just give some examples. Often I guess I've seen clients with seeking to demonstrate mental incapacity. So in that case, the department is wanting evidence from a psychiatrist or a medical practitioner who is a fellow of the Australian Society for Psychological Medicine, or a psychologist who is registered with the Psychology Board of Australia, has a practice endorsement in that area, and is registered with Medicare as a specialist. And some examples, just to get more plain English, are clinical psychologists, forensic psychologists, or clinical neuropsychologists seem to fall into that category. So again, letters or reports from GPs are not considered sufficient. However, the policy does make a bit of an exception for clients in rural and regional areas where perhaps those specialists are not available. So in those cases, the department may accept evidence from a doctor who is a fellow of the Australian College of Rural and Remote Medicine. So that's for mental incapacity. Then for physical incapacity, the type of specialist report depends on their type of incapacity. So yeah, I think if it wasn't obvious, then we could seek direction from the department about which specialist they wanted the applicant to see. In terms of what the report should include, so they need to be fairly detailed. They need to set out the applicant's details, how long the specialist has been treating the applicant for, and that might just be setting out how many appointments they've had and the dates of the appointment, whether the applicant has received treatment from any other specialist in the field, when the incapacity commenced, are they currently being treated under a treatment plan and what that involves. In the case of mental incapacity, the specialist should note any cognitive or other testing that has been done and the results of those tests. And then the specialist should articulate a clear basis for the diagnosis and opinions in their report, such as explaining how the incapacity relates to the person not being able to understand the nature of the application or demonstrate basic English or demonstrate adequate knowledge of Australia and citizenship. And then again, needing the specialist's full credentials and the basis on which they're making their findings. Some common issues with reports. So I often see applicants who've submitted letters from their GP, but as we said, that's not enough. With mental incapacity, I think a specialist who's only seen the applicant once and is writing the report straight away, that's probably not going to be sufficient, unless maybe this specialist was relying on previous reports written by also qualified specialists. Another issue is that specialists are not really used to writing these reports, and so often they're not sufficiently detailed or they don't cover everything that the department wants to be included. So if Legal Aid is assisting an applicant with their citizenship incapacity matter, one of the things we often would do is write to the specialists and explain exactly what the report needs to cover, or to give them feedback on their reports and point out that they haven't addressed a particular issue and could they include that. And another issue is that the applicant needs to have that incapacity at the time of the application for citizenship. So with something like depression or PTSD, providing a report that's from 2 years prior, or a report from 6 months after the application is lodged, may not be sufficient to show that the incapacity was present at the time that they lodged the application. And then finally, we've got, what if the department tries to send your client to the department's specialist, or the person, someone that they recommend? So I'm aware of some examples of that happening, and where the applicant I guess was very upset by what happened with when they saw the department specialist. So I think if this happens, some issues to consider would be the applicant's willingness to see a new specialist. whether it's in the best interests of the applicant to do that, or whether it might be traumatizing to see a new mental health practitioner and have to recount their whole history again. Also, the cost of seeing a new specialist, and because that can be quite high. And then also whether this should really be necessary to see a second specialist, or whether the evidence already provided is enough to meet the legal and policy requirements for citizenship. And that's something that Legal Aid could give your client advice about before they decide whether they want to see this other specialist.
So someone's asked a question, Roxana, can the client refuse to see the department specialist?
Yes, they can. That's something we would talk through with the applicant about whether it's what the likely outcome of that might be. I have had a client who was asked to see a psychiatrist or psychologist recommended by the department, and we felt that the applicant had already provided more than sufficient evidence, and we wrote back a kind of, I guess, a legal argument about why what we had already provided was sufficient and why it wasn't appropriate for the applicant to see this new specialist. In that case, we ended up being successful. So yeah, it is possible to decline and still be successful with the citizenship, but I think it would really depend on the circumstances of the case.
And so do these reports cost a lot of money, Roxana? Do you know?
Well, just having an appointment with a specialist can cost a few $100s, and then if you need to see the specialist a few times before they know you sufficiently and have done enough evaluation to write a good report, then it can really add up. And I guess some specialists charge a separate fee for writing a report that's in addition to the appointment fee. Yeah, so it can be expensive.
Yeah. And can Legal Aid help with that at all, or is that?
No, not with funding the specialist fees. I don't believe so. Yeah.
Okay, well, I don't have any other questions from that. Did you want, you ready to move on to the next slide?
Yep.
Okay. So what about if the impairment or incapacity happens after they've lodged their application?
All right, so this, for example, if your client has applied for citizenship using the general citizenship form and they intend to sit the test, but then, for example, they have a major stroke. So this will cause a problem for the citizenship application, because let's say they're no longer able to sit the test. But for using the other pathway, the incapacity pathway, one of the requirements is that they had that incapacity at the time of the application. So in this case, the person would need to withdraw their original citizenship application and reapply for citizenship, but this time using the alternative form, which is for applications based on incapacity, because there's two different forms that are used.
Right. So people can contact you for legal advice around that if that happens?
Yep, that's right. Yep, definitely.
Okay, so tell us about how you can help Legal Aid New South Wales.
Yep, so we give advice on citizenship. That's not means tested, so anyone can get advice from us about their citizenship application. We generally don't help most people to fill in their forms or prepare their citizenship application. We do offer to check citizenship applications once they're drafted, just to kind of give them a look over before they're submitted, and to answer any questions if someone was unsure about a couple of the questions in the forms. However, in some cases, we do offer what we call extended legal assistance for citizenship cases, and that includes where the application is being used, sorry, where the applicant is seeking to use the incapacity grounds, and also where the applicant is a refugee with identity issues or difficulties providing enough identity evidence. So in those two situations, we do a bit of an evaluation to see whether we can provide additional assistance. And that could include preparing the citizenship application, or it could involve correspondence with the specialists who are providing the reports, or responding to some correspondence that's been received from the department, for example.
Okay, thank you. So we're going to do another poll question with our audience. I'm going to launch that poll now. So the poll question is, who does not need to do the citizenship test? And you can choose more than one answer. So I'll let people choose their answers.
This is just to see if you've been paying attention.
That's right. Which I'm sure they all are, because we got a question. So that's always a good sign. So people are voting now. I'll just give them a few more options and time, see from our people who are here today, see how they're voting. Okay, so I think most people have voted. So what I'll do is I'll close that poll and share the results with you, Roxana. You'll be very happy. So
Oh, wow.
92%
Good.
people said 60 and older.
Yeah,
Nobody
that's
said people
correct.
unable to get to English.
Mm-hmm.
85% said people with incapacity with good specialist reports.
Yep.
100% said people aged under 18, and no one selected anyone with a letter from their doctor.
Wonderful. Either you already knew it already, or you've been paying good attention.
So that's great. So it looks like the key messages have got through.
Yeah.
So our next slide for you to talk about, because I'm sure there's community workers here today who've had their clients in this situation of having their applications refused. What should people do then?
Sure. Okay, so we've just got there some of the common reasons why citizenship might be refused. So including character findings, uh, insufficient identity evidence, or failing to pass the citizenship test. Or it could be that they've sought one of these exemptions based on incapacity and been refused, or said that their evidence for that is insufficient. So if your client is refused citizenship, I would suggest they get urgent legal advice, which could be from Legal Aid, to discuss whether or not to apply for a review by the Administrative Appeals Tribunal. In this case, because there'll be a strict deadline for applying to the tribunal, so when you or they are calling Legal Aid for an appointment, just let us know the deadline for applying to the tribunal so that we make sure we try to accommodate that. But I guess in some cases it is worth applying to the tribunal. But in other cases, it may be just simpler and cheaper to lodge a fresh citizenship application and start again that way. There's no waiting period or to make a second citizenship application. So that's something that we would help the client evaluate which of those two options they want to do, or in some cases they may just need to wait a few years before trying again for citizenship, especially if it's been a character refusal.
Okay. And is there a limit on how many times you can apply to
No,
be a
there's not.
No.
No, you can keep applying. Yeah, but
Right.
a bit of effort required. So it's good if we can have a chat with them about what the chances of success are, or whether there are things they need to do before applying again.
And when you said you wanted, it's a good idea to let you know about the time limit, that's on the letter, is it, that they get with the refusal?
Yes, that's right. Yeah, the letter should tell them about their appeal options and give the time frame.
Okay, great. All right. So you're now going to talk to us about citizenship delays by country.
Yeah, so look, this is not entirely relevant to the topic, but I know it's a big issue and that your clients may experience long delays after applying for citizenship, and they may get worried that that means there's something going awry with their application. Um, but the fact is that the department says they currently have about 140,000 citizenship applications to process, and there is a delay for everyone. So they currently say that 75% of citizenship applications are processed within 14 months, plus then another 6 months to wait for a citizenship ceremony. But processing times vary greatly and are particularly long for many people who have come to Australia as refugees. And so that's kind of what the statistics on the screen there are showing you is an idea of the scale of the delay and the inconsistencies experienced by applicants from different countries. So, yeah, for example, people from Afghanistan seem to experience particularly long delays,
Mm.
compared to people from India, for example, who generally have better identity documents. They're not waiting as long.
And where
And
do
then
they, oh, sorry, I was just going to ask, is this information readily available on the website or?
this particular information by country was something we obtained through a Freedom of Information application. So no, it's not generally available. But we the long delays for clients from particular countries were obvious, and so we wanted to get some data on that.
Mm.
If we go to the next slide, this is a similar issue, but this is showing delay, that the delay is quite different depending on the type of visa that the applicant holds. So particularly long delays for people who have protection visas, and then kind of moderately but still long delays for people who've come with humanitarian, women at risk or refugee visas. Yeah, so I mean, partly I wanted to show you that so that you're just aware of how long your clients might be waiting for their application to be processed. And I think sometimes people, while still being frustrated, feel like at least they realize it's not just them who is waiting for so long. It's many people in that situation.
And we've had a question, Roxana. Generally, what is the reason that applications for refugees takes longer? Is it because the applications are scrutinised more?
I suspect that is part of the reason. The more, I guess, legal reasons would be that so one of the criteria for citizenship is to satisfy the Department of Identity, and people from refugee backgrounds may not have good identity documents. In some cases, they may have come to Australia with no identity documents. In some, kind of war-torn countries, there might be very poor record keeping and no way for people to try and apply to get documents from their home country. So, for example, countries where birth certificates are not issued or available, they will have particular difficulties establishing identity. The department is ideally looking at identity from birth. So they're not really interested in your Australian driver's license or documents that have been obtained after arriving in Australia. They're wanting to confirm your identity before you came to Australia. So that's something that we, again, can give clients advice about, what might be available from their country, or if they're from a country where records are not available, you know, there are some alternative ways to try and convince the Department of Identity, including through witness statements and things like that.
So the other question is, if a refugee has a current or past legal case against Department of Home Affairs due to their refugee experiences, will this impact on their citizenship application or outcome of the application?
It shouldn't be relevant. There is a character criteria, so you know, the mere fact of having appealed or taken some administrative action, you know, that shouldn't reflect on someone's character at all. But you know, if there were other issues such as disturbances in an immigration detention centre or something like that, or the department alleging some kind of fraud in an application, then that could be relevant to the character test that's part of the citizenship criteria.
So they're the sort of things you can talk to people about if they're refused.
If they're refused, or even before they apply, we could have a chat about, you know, if they think they might have some kind of criminal record or problematic record somewhere, you know, we could have a chat about that and try and if they're not sure what you know, might have on a record somewhere, we can talk about trying to find that out first, and then considering whether it's a good idea to apply for citizenship.
Okay. And someone's asked if it's okay to share this presentation we're using today with their co-workers. That should be okay.
Yeah, I think that should be fine. Yep, the slides alone don't have a lot of text
Content.
in them, but yeah, you'd be welcome to do that. Just keeping in mind, of course, that you know, sometimes this information does go out of date.
Yeah, so we've got it dated June 2021.
Mm-hmm.
Okay, so how can people refer their clients to you, Roxana?
Mm-hmm. Okay, so there's a few ways. So we have our immigration team in the head office. So by calling that number, the client can be booked in to receive advice, usually in that coming week. We also offer immigration advice in a number of outreach locations. So pre-COVID, we were going to these, you know, out to Blacktown, Liverpool, Fairfield, Bankstown, and Auburn. At the moment, this is not happening. It's by phone just at the moment, but we're hoping to resume those outreach clinics in the near future. So it's up to you or your client, you know, which way they want to book in. Once we resume the face-to-face appointments in the outreach locations, they're probably a good way for clients who have documents that they want to show us, or who aren't very maybe tech savvy, or you know, feel more comfortable coming to have a chat in person. I would recommend to contact one of, you know, and if they live in those western or southwest areas of Sydney, then you're welcome to book in through those outreach locations. So yeah, but at the moment it is all by telephone, and where their client has documents for us to look at, you know, we're asking for them ideally to be scanned and emailed to us so we can be looking at them during the appointment.
Oh, okay. When they make the appointment, they talk to them about that.
Yeah, so often it's hard to give advice without looking at the relevant documents, especially if they've already applied for citizenship and received some kind of letter or if they've been refused citizenship, we'd be wanting to look at the refusal decision and look at the reasoning given there.
So that's how community workers can help, definitely.
Yeah, by helping, that's right. And we haven't put it here in the slides, but in the follow-up email that we will send out, I can also put in an email address which community workers can use to make warm referrals to us, where they can provide, the client's details and attach relevant documents as well.
Okay, thank you. So there's a question here, but I think we'll just move forward from this. Oh, I just wanted to check with you, Roxana, confirm that it's a statewide service. It's not only Sydney based, is it?
That's great. So yeah, the Legal Aid and our immigration team provide us a statewide service. So if you are outside of Western or Southwest Sydney, where we have those outreach locations, then the best thing to do would be to call that head office number or to use the email referral method, which we'll send around later.
Okay, thank you. So people can start typing your questions now. This is just to let you know that we run these webinars for community workers regularly, and you can find the details on our what we do workshops and webinars page on our Legal Aid New South Wales website. And the next one coming up in 2 weeks is Legal Words for Interpreters, looking at crime, words used in criminal proceedings. So you can find that on our website to be able to register. And yeah, so now we're at the end and we're going to take some questions until 2:30. So I'll just start, Roxana. One of the questions is, if clients cannot read and write English, they can provide support letter. So can you help them to be exempted from the test?
No, so that's what we were talking about earlier, that if someone can't read or write in English, that is not a sufficient reason to be exempt from the test. The only way would be is if that was due to a mental or physical incapacity. For people who can't read or write in English, there are those study materials available in some other languages on the Department of Home Affairs website. And also, I guess, to look around for citizenship study groups, which some of the migrant resource centres offer in different languages. But yes, I agree, it's very hard to prepare for the test without English. I mean, I guess the other strategy, of course, is to, for people who are able to attend the English classes that they're eligible for and try to work on their English, of course. But I know that's not always possible.
And someone's asked, can you change an appointment time for a citizenship test?
I've heard of people delaying their appointment times because they need, want to do more study or preparation, or I'm not sure how easy it is to swap, say this time's doesn't suit me, can I have another time? I'm sorry, I haven't tried to do that myself.
Okay. And another question is, well, it's actually a comment that we've got many clients with citizenship test issues. Good to know there's no limit for how many times we can reapply.
Yeah, so that's right. So I guess they'd be taking the 3 attempts available to them, but if they can't pass the test and the application is refused, then yes, they are definitely able to just reapply. Of course, they have to pay the application fee again, but it's, citizenship doesn't cost as much as, say, applying for a visa. So yes, they could just reapply as soon as they're ready.
And the next question is, do we attach the specialist medical reports when we lodge the application?
That would be ideal to do that, yes, because well, partly you're providing what the department needs, and so ideally that would allow for more efficient processing. And also, as I mentioned, we're trying to show that the incapacity existed at the time of application. So if you have a current report that you can put in with the application, then yes, definitely I'd do that. And make sure you
Okay.
keep a copy of both the actual application and the specialist report for future reference.
Are they lodged online, Roxana, and do you get a receipt when you do that?
So you can lodge citizenship applications online or using a paper form. Yes, you'd get a reference number either way. I'm not sure with the online applications whether you automatically get a full copy of what you've submitted. Yeah, if that was the case, I'd be probably keeping my own screenshots or copies of anything I've uploaded.
Okay. I think that's all the questions we've got so far from people.
Mhm.
So
Okay.
you've been
I,
able to
I just
answer
I
all
just have
those. Yeah.
one thing to mention, which is that if someone is granted citizenship through the incapacity provisions, my understanding is that they then would receive their citizenship certificate by post, and they wouldn't be invited to a citizenship ceremony. You know, that may disappoint some people who want to go to a ceremony, of course, but it also means that they're getting their citizenship quicker because it can take 6 months or longer to be invited to a ceremony sometimes. So yeah, pros and cons of that.
Mm. So someone's asked, do you have to create a IMI account?
To do the online citizenship application, yes, that is through an IMI account. But there is also the paper form option still available. Yeah.
So someone's saying they've got a client who did their application last year and it was certified then by a JP and the GP. So would you suggest they lodge it now or get a new application and restart the process if it was filled out last year?
I'm not entirely sure about the circumstances here. So if this is an application on incapacity grounds and all that they provided was a letter from the GP, then yes, that application would have a problem. If the person was actually seeing a specialist back at that time, though, they may be able to now get a specialist report which covers the relevant time period. And that might be able to kind of sufficiently supplement what they've already put in. But if they weren't seeing any specialists back at that time, yeah, I think we really have to think about whether they can meet the requirements at the time of application or whether they need to reapply with a specialist report.
Okay. All right. Okay, I think some of these maybe you might need to have a look at offline. But someone's
Mhm.
just asking about paying for the application. Can you do that at the post office or?
No, so paying for the application is trickier now. So you do have to pay for the application through an IMI account, even if you then lodge the paper form. So yeah, it is tricky, and I mean, luckily I know some community workers know how to pay the fees online. Um, it doesn't have to be your own IMI account; it could be anyone's IMI account, as long as they give you the receipt number. But if people are stuck with that, that's something that we can give advice about over the phone and guide people through how to make the payment.
Okay, great. All right. And just to let everyone know that Roxana will get a copy of the questions you've asked, and if there's anything that we haven't covered and she feels she can contact you directly, she will do that. But you do have the numbers now that are on our on the presentation on how to get in touch with our service. So you could always just make an appointment for your client and get them to have a chat directly to one of the lawyers. And then they can also, as Roxana said, have a look at the paperwork that you may be referring to, which is really important.
Just before we finish up, I'll just make a comment about who I recommend should get legal advice about a citizenship application. So look, some people may not require legal advice, but the people who I would particularly suggest to get legal advice are people who are considering using those incapacity or impairment provisions, clients with any kind of criminal record, clients who are here as refugees but at some point have travelled back to their home country, because that travel may cause a character problem. It's just good to have a chat about that. Also clients who don't have good identity documents from their home country. So that they are all people who I would suggest would benefit from getting advice before putting in a citizenship application. Also people who don't remember or don't have a copy of their old visa application, or not sure what they said, or someone else filled it in for them because they didn't have enough English. We would really recommend that people get a copy of their old visa file from the Department of Home Affairs through Freedom of Information, just to be able to double check and confirm what was said in that original application, and if there are any inconsistencies or errors that come up, then it would be good if they had an appointment for legal advice to have a chat about that.
Great, thank you. People are saying thank you very much, Roxana, for your information today.
You're welcome.
So, all right. Well, I just want to say we've reached the end of our time. So thank you very much, Roxana. And we do really appreciate your time today and all the information you've shared with us about the work of the immigration team here at Legal Aid New South Wales and how you can help with this important issue for the clients of the workers with us today. Just a reminder about two things. You'll get a survey after we close the webinar. We'd really appreciate your feedback, and also an email about an hour after the webinar closes with the links, including that email address that Roxana talked about. And yeah, so on the screen now is the Legal Aid Community Legal Education Team email address, cle@legalaid.newsouthwales.gov.au. So if you're watching this as a recording, you can send your questions there and we'll pass them on. And also don't forget the Law Access New South Wales number for free legal help on a whole range of legal problems, 1300 888 529. And we look forward to welcoming you all to our next Law for Community Workers webinar. And we'll say goodbye for now. So bye, Roxana.
Bye. Thanks, everyone. I look forward to your referrals.
Perfect. See ya.